Hi, Georgia,
Hi, Alex.
and welcome listeners to the first episode of our series, Further Particulars, where we discuss significant developments in personal injury law in Queensland and beyond.
And today's topic certainly falls into that category. Today we're talking about the High Court's decision in AA against the trustees of the Roman Catholic Church for the Diocese of Maitland, Newcastle. Now, before we dive in, a quick but really important note for our listeners today. This episode discusses events involving child sexual abuse. While we won't go into graphic detail, the subject matter itself can be quite distressing, so please take care while you're listening today.
Yeah, thank you, Georgia. It is a heavy topic, but it's also a hugely significant legal development, one that has reshaped the landscape of non-delegable duties in Australia, and it's just too important not to talk about.
Absolutely. So we thought the easiest way to explain the decision and its ramifications was to take our listeners from the older approach to non-delegable duties in the High Court's decision in a case called Lepore through to the major shift in the 2026 AA decision.
Yes, awesome. Okay, so for the benefit of our listeners, what's a non-delegable duty?
That's a great question, Alex, and it's certainly not an easy topic by any means to
No.
grasp, let alone explain. So please put up with me to be able to do that today. But a non-delegable duty in its most basic form is a special kind of duty of care. It's one that requires you not just to take reasonable care yourself, but you must ensure, and AA in the decision is quite focused on that word ensure, that you must ensure that reasonable care is taken by anyone acting on your behalf. Now, we see this in relationships like schools and students, patients and doctors, and employers and employees too.
So it's basically a higher standard than ordinary negligence, and it arises where someone is vulnerable and relies heavily on the duty holder to take care for their safety.
Exactly. And now the big question for a really long time was, does this duty extend to intentional criminal acts? For example, and relevantly to the decision in AA, a teacher or priest sexually abusing a child.
Yes, and according to the decision in Lepore, the answer was basically no. In Lepore, the court said that you can't breach a non-delegable duty by an intentional assault because that's not negligence, and that resulted in some really harsh outcomes for victims.
Well, yeah, exactly, because institutions could easily say, well, yeah, terrible things happened, but that wasn't exactly negligence on our part, so we shouldn't be liable for that.
Yes, and this meant that victims often had no avenue for redress despite being harmed in environments that the institution had total control over.
Exactly. And so before AA, a few cases started hinting that Lepore wasn't sitting comfortably anymore. One example is the High Court's decision in Wilmot, where the court emphasised the state's deep responsibility for children in its care.
Yes, that's right. In Wilmot, the court said that if the state stands in locus parentis, it can't simply say, oh, well, someone else abused the child. That's not our problem.
And it's that kind of reasoning that really did pave the way for the High Court to reconsider the foundations of Lepore. And then we get to AA. Now, in AA, the plaintiff had been unfortunately sexually abused by a priest in 1969, and the lower courts felt bound by Lepore, so his claim failed.
Yes, and so on appeal, the High Court took the opportunity to ask, should Lepore actually still stand?
Yeah, and the answer was no, which is a fabulous development. Basically, the court overturned Lepore and held that a non-delegable duty can be breached by intentional criminal acts. And what I found really striking in the court's reasoning is that the duty instead focuses on the relationship between the diocese and the child, not the relationship between the diocese and the perpetrator.
Yes, that's the key shift. It's about the diocese's responsibility for ensuring that children in their care are safe, full stop. So, I thought we could go through a couple of the court's important points. The first being that a plaintiff does not need to demonstrate that a particular priest was dangerous. So, in legalese, that means that the plaintiff does not need to show that the priest's conduct was foreseeable.
Right. And foreseeability just means that a reasonable person would see this kind of harm to this class of vulnerable children was a real risk and not a far-fetched one.
Yes, and secondly, the child does not need to be harmed on church property. If the priest's conduct, supervision, and control of the child arose by virtue of their role as a priest, that's enough.
Yeah, and that makes sense because otherwise you'd have really arbitrary distinctions like, yes, we owe you a duty in the presbytery, but not if the priest abused you in the car on the way home.
Yes, exactly. Now, G, where do you think that this leaves us? The court has changed the scope of non-delegable duties in Australia in a major way.
Well, exactly. Institutions can't hide behind arguments that abusers' actions were not a part of their role. The focus is now on vulnerability, responsibility, and really the reality of institutional power and how it operates day to day.
This is a major win for survivors, particularly of historical abuse, and it certainly aligns the law more closely with the community's expectations of institutional responsibility.
Absolutely. It finally holds institutions responsible for the safety of the people that they take into their care, and it's actually giving survivors a much fairer shot at justice.
Yes, I think that this was a really good place for us to start, G.
It sure was, Alex. Thank you so much to everyone for listening to Further Particulars. Stay tuned for our next discussion regarding the latest data we've analysed from the Motor Accident Insurance Commission and how Queensland motorists who are making CTP claims without legal representation are being exploited by the insurers. See you next time, guys. Thank you so much for your time.